Bloomberg Audio Studios. Podcasts, radio, news.
This is Bloomberg Law.
Employers frequently exploit the weaknesses in the law.
Courts are going to be asking questions about separation of powers.
One by one, Google settled with all of these other plaintiffs.
Interviews with prominent attorneys and Bloomberg legal experts.
Joining me is immigration law expert Leon Fresco, First Amendment law expert Caroline Malik-Corbin,
and analysis of important legal issues, cases, and headlines.
The trial judge may well want to hold a hearing. They have never said this case should never have been brought in the first place.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to the weekend edition of Bloomberg Law. I'm Amy Morris, in for June Grasso. June's off this week. Coming up this hour, we'll be focusing on a couple of major antitrust cases. We'll break down the Justice Department's case against Live Nation as that trial gets underway. We'll take a deep dive on why baseball is exempt from antitrust laws. All of that is on the way on Bloomberg Law just ahead. But first, let's begin with Elon Musk's big securities fraud class action case. The billionaire took the stand in federal court in San Francisco to defend himself against claims that he deliberately drove down Twitter's stock price before he bought it by tweeting. Bloomberg's Jeff Ely is in San Francisco. He's been following this case and joins us now to bring us up to speed. First of all, Jeff, the tweet that is at the center of this case, what did that tweet say? What was it about?
It was a tweet in May of 2022 in which Mr. Musk, who was frustrated by Twitter's foot dragging on handing over information that he wanted tied to the deal, he basically tweeted out that he was putting the deal on hold temporarily until they could give him the material he sought. That same day that he issued that tweet, he also issued a tweet saying he was still committed to the deal. So, he claims that it was frustration. The investors who are suing him claim instead that it was really part of a campaign to drive down Twitter's share price so he could buy it on the cheap.
Let's talk about that. Your story on the Bloomberg terminal says that this trial is going to take a closer look at that 6-month window when Musk was going to take over Twitter, then tried to withdraw the offer, and then went through with the deal because the company sued him. What's the line that may be crossed here between someone having second thoughts about a deal or just being flaky about a deal versus someone deliberately trying to manipulate a deal? Is that what they're trying to prove?
Right. That's exactly what they're trying to prove. In M&A litigation, which we cover a lot of in Delaware, you're always going to get allegations of buyer's remorse. M&A situations are always tied to the market. Market fluctuates. The bases for deals can be affected. Here, the investors contend that it was not fluctuations in the market that really drove Elon to start thinking about trying to reprice the deal. It was really the fluctuations in the Tesla stock price. He was using Tesla shares to both generate cash for the deal and secure loans, and they took a dive during that period, and that made the deal much more expensive for Mr. Musk. So the investors contend that he launched a organized campaign to attack Twitter in hopes of driving down the stock price so he wouldn't have to pay as much for the company.
Now, he did wind up paying $44 billion for Twitter.
That's right.
Did they intend for him to pay more, or is there a share price that should have been up instead of down, or where's the discrepancy?
Well, the discrepancy here is the deal. The timeline is Mr. Musk makes an offer. Tesla shares crash. Mr. Musk attempts to renege on the deal. Twitter sues. Mr. Musk countersues. And then after some pretrial rulings from the judge in Delaware that were not favorable to Mr. Musk, he decided to wave the white flag and pay the full 54.20 per share that he had originally offered. So, this is a you always have two versions of reality in legal disputes, and this jury's going to decide which one of the views of reality sound more plausible to them.
So then what do the investors want? If they ultimately got the money that he had promised, what do they want out of this?
These are some investors who, when Mr. Musk issued his May 13 tweet, decided or figured that he was pulling out of the deal, and they sold their shares in the 30s rather than getting $54.20 per share in October when the deal closed.
I see. So it's about them having sold their shares based on the idea that he's backing out.
That's right. And under securities fraud, you are barred in an M&A situation from making a false or misleading statement that would affect, the market. And the investors contend that that's what this deal placed on temporary hold was. It was a false or misleading statement.
Isn't that interesting? I was thinking about how this is basically all based on a tweet and how unusual that is, because there's no documentation. There's nothing signed. He could probably argue that it was just something a thought that he just tossed out there.
That's exactly what he's arguing, by the way.
I nailed it. So there's no documentation there. There's nothing signed. He could argue that it was just a thought that he tossed out there, which is what he did. How would this change how future securities fraud suits might be handled? Social media may be changing how the courts are looking at this, how juries are looking at this. Is that actually a factor now?
I'm not sure. You might argue that you're going to have more securities fraud because people, are availing themselves of public platforms like Twitter, which is, of course, now called X. I think this is pretty much, your garden variety federal securities fraud. It's being tried in federal court in San Francisco, by the way. And I don't, it's all going to come down to whether the jury believes that Mr. Musk had intent to drive the stock price down. And that's very hard to prove. Okay. So, this is no slam dunk by any stretch of the imagination.
For those who are suing, for the investors?
Correct.
Because they have to show intent.
That's right. And, in a criminal case, as you know, intent is inferred. If you point a gun at someone and a gun goes off, you are, the law basically infers that you intended to kill that person. Civil court, completely different. You don't have that, beyond a reasonable doubt burden that you have to meet. You have to somehow get, persuade the jurors that 51% of the scale tips in your favor when it comes to intent. But it's just very difficult to prove.
How long would a case like this last?
They're thinking this is going to take roughly 2 weeks to try.
Wow, that seems pretty quick for a securities fraud case.
Well, you're basically giving each side a week, right? And it's you can do it in that. Again, there's not a lot of ground to cover here. Right? Two or three tweets and a podcast. That's the sum and substance of the allegations that were allowed to go to trial. The judge knocked out other allegations.
Okay, Jeff Feely, thank you so much for joining us with this. We do appreciate your insights and your time. Thank you so much.
Sure, Amy.
And our thanks to Bloomberg's Jeff Feely for joining us. Now let's turn to the entertainment space and a highly anticipated antitrust case involving Live Nation. It is a massive entertainment company, and they're in court to defend themselves against claims from the Department of Justice that it monopolized the live music market, acting as the biggest ticket seller while also running and, in a lot of cases, owning some of the nation's biggest concert venues. The trial just got underway in New York. Joining us now to talk about what comes next, Bloomberg News antitrust reporter Leah Nyland. Leah, thank you for taking the time with us.
Thanks for having me.
So, for years, let me just come at it from a fan point of view. For years, those of us who have attended concerts and bought tickets through Ticketmaster, which is owned by Live Nation, have complained about the cost, complained about the monopoly. And those are just the fans. That's not even the venues and the concert promoters and the agents and those who have also had to deal with Live Nation. Bring us up to speed how we got here.
Yeah, so Live Nation bought Ticketmaster. They used to be separate companies back in 2010. At the time, this was during the Obama administration. There was an antitrust review of the deal, and they were concerned because Live Nation is what's known as a concert promoter. So they own both a bunch of concert venues, but they also help promote concerts. So they have people who help artists sort of pick out which venues that they're going to perform at and then arrange all of the details of a tour. And they wanted to buy Ticketmaster, at the time the largest ticketing company. The Justice Department decided to allow this to go through, but with some conditions. And the conditions were that Live Nation could not retaliate against any venues that wanted to use other concert promoters or other ticketing services. So the merger was allowed to go through. Everything went along, but the Justice Department alleges that Live Nation repeatedly sort of violated a lot of these orders. There were allegations that they were threatening venues to sort of make them use Ticketmaster, which is why something like 87% of venues across the United States use Ticketmaster instead of other ticketing options. So the Justice Department went back to court, changed its sort of agreement with Ticketmaster to one in which it had a monitor and it had a lot more obligations. And they feel that that didn't work either. This sort of bad conduct continued. So the Justice Department under the Biden administration started a new investigation. And in 2024, they sued Ticketmaster for being a monopoly in multiple markets. Now, some of the case ended up getting thrown out before trial, but on Monday, I guess, it went before a jury in New York. The case is supposed to take several weeks. We're thinking probably 5 to 6 weeks, and it's going to feature testimony from people all across the live music industry. So there'll be people from various venues. There'll be people from Ticketmaster. There will be music artists. Kid Rock and someone from Mumford & Sons are both supposed to testify, as well as just some regular fans about how Ticketmaster controlling so much of the industry has sort of impacted things.
Okay, Leah, let's hold it there for just a moment. We are talking with Bloomberg News antitrust reporter Leah Nyland. We'll have more with Leah about the big Live Nation antitrust case. That's just ahead. I'm Amy Morris, in for June Grasso. You're listening to the weekend edition of Bloomberg Law.
You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
Thanks for listening to the weekend edition of Bloomberg Law. I'm Amy Morris, in for June Grasso, and we've been talking about the Department of Justice antitrust trial against the live entertainment giant Live Nation. Bloomberg News antitrust reporter Leah Nyland is with us. The crux of the DOJ's case against Live Nation, Leah, is that it has a monopoly on live entertainment because it owns Ticketmaster, which is the nation's largest ticket seller in the nation. And Leah, one of the things you mentioned is that at the very beginning of this, back in 2010, when the judge allowed for this merger in the first place, even then the judge said, don't threaten concert venues. If they don't want to use your services, you can't intimidate them. The judge said that from the beginning. So is that what they're accused of doing?
So that is one of the allegations that the Justice Department is seeking to prove. The very first witness, in fact, was the CEO from the Barclays Center, which is a large concert venue in Brooklyn, New York. And they are one of the venues that allege that they were sort of threatened by Ticketmaster. Ticketmaster, they had wanted to switch their ticketing provider away from Ticketmaster to SeatGeek, which is another ticketing provider that it primarily does a lot of sports related events. Thank you. SeatGeek primarily does a lot of sports related events. So Barclays agreed to switch to SeatGeek, and they played a phone call in court with the CEO of Barclays and the CEO of Live Nation. And the CEO of Live Nation said, if you switch away, it's going to be hard for us to keep sending you concerts. And then after they switched to SeatGeek, the allegation is Live Nation started moving concerts, popular concerts, to another concert venue in Queens instead of this one in Brooklyn. And so there was some talk about a Billie Eilish concert that had been booked at the Barclays Center, and all of a sudden it got moved to this other venue.
So they're not just switching venues, they're actually moving acts from a venue that was already booked to a different venue that uses Ticketmaster.
Yes, and that is the allegation that the Justice Department was focusing on. Live Nation maintains that this was at the choice of Billie Eilish's team. Barclays, the Barclays CEO said, they had somebody check it out, and Billie Eilish's team said that this was in fact a request by Live Nation. So it is a little bit disputed, but the Justice Department is planning to put on a number of other venues who allege this happened to them. They would look at switching to a different ticketing provider, and Live Nation would say, well, if you switch to somebody else, we're not going to be able to bring you the same tickets. Live Nation has argued all along that it's sort of under no legal obligation to do business elsewhere, that, it makes most sense for them, like business-wise, to put concerts at either venues it owns or venues that are using Ticketmaster because, when it's a vertically integrated company, it's cheaper for them. And so that's actually one of the major issues in the trial is this like a legitimate business practice, or is this sort of unfair coercion? Does this practice of them trying to tie their contracts in this way make it illegal and sort of force pressure on these venues to use Ticketmaster instead of other options? The other interesting thing here is that the case is being brought not just by the Justice Department, but by a number of state attorneys general. And state attorneys general do have the right to sort of seek damages on behalf of their citizens. So there are 25 states, 24 in D.C., depending on how you count it, that are seeking damages from Ticketmaster on behalf of concert goers. They say that because of Ticketmaster's monopoly, ticket prices were increased by at least about $2 per ticket. So obviously $2 a ticket is not that much, for an individual ticket, but we're talking about something in excess of like 20,000 concerts at thousands of concert venues across the country. So if you add that all up, we're talking about damages in the potential millions or billions of dollars, depending on what the jury finds.
You cover antitrust cases a lot.
I do.
This is your jam. So what criteria then do they have to meet to show that, yes, they violated this? So
first, the jury has to find that they're a monopoly. That's not really that contest. There is a little bit of contention here about whether they're a monopoly. It depends on what venues you consider to be in the market versus not in the market, because the government first has to show that they have the power to sort of exert undue influence. The government says that Ticketmaster controls ticketing at about 87% of what they're calling major concert venues. So these are the venues that generally, like the thing that they do the most is hold music concerts.
Sure.
Ticketmaster says that that's not really the appropriate market, that it should include sort of all spaces that could potentially host a concert. So in addition to like something like an amphitheater or an arena, it should also include a stadium. And so if you consider all of those things, stadiums, amphitheaters, arenas, their market share is a little bit smaller. It would be only about 40%, which there isn't like a legal definition of what a monopoly is, but generally it's considered to be at least 50 to 60%. So that's one of the things the jury will have to decide. Should they be considering every single place that a concert should take place or just sort of major concert venues? The Justice Department argues that, there are only certain artists who are going to be able to fill a stadium, someone like Beyonce. So if you are a, up-and-coming artist, you're not really going to be playing a stadium. You're going to be playing some of these smaller places. Sure. And those are the places where Ticketmaster has a little bit more power because most of the business they're doing is music concerts.
So are we also including nightclubs in this?
Yeah. So they sort of start, they have a bunch of people from sort of the music industry who are taking the stand and sort of talking about this. When an artist starts, they tend to start in smaller venues like clubs, and then they move up to amphitheaters, and then they move up to arenas. And then if you're very, very popular, you move up to a stadium. So the Justice Department's case is sort of focused on those slightly smaller ones, the clubs, the amphitheaters, the arenas. These are like places that have maybe like 1,000 to maybe 20,000 seats, whereas a stadium is going to have like 40,000 to 50,000 seats.
Sure.
So it's focused mostly on those. So we're not going to be hearing from people like, Beyonce or Taylor Swift, although Taylor Swift's concert agent is supposed to testify. It's mostly focused on like mid-level artists. So the people who are definitely testifying are Kid Rock, who has been very interested in this case and is close friends with President Trump. And then also one of the members of the Mumford & Sons band is expected to testify. So like artists along that sort of caliber who do a lot of shows and can talk a little bit about how, Live Nation's control over concert promotion has really impacted where they end up performing.
So what is the court then being asked to decide here?
So there is a jury for this portion, and the jury is being asked to decide first whether Live Nation is a monopoly, and then second, what if they are a monopoly, what the damage amount per ticket is. So there will be some testimony from all of these people about Live Nation's conduct, and then there will be some testimony from experts about how Live Nation's conduct impacted the price of tickets. Once the jury decides that, and if they decide in favor of the government, the judge would then take the jury's damage number and sort of decide the overall damage number. So they're deciding per ticket, he's deciding the overall number. And then he will also decide whether there are any additional remedies needed. So that's where the potential for a breakup comes in. Because the government has said, we allowed this merger to take place in 2010 on the condition that Live Nation sort of not engage in bad conduct. And they have been doing that the whole time. And so really, we tried to allow this to go through. It hasn't worked. And so what we really need now is to break up this company.
So this might seem like an out of the left field question, but I wonder how ticket resellers like StubHub would somehow be involved in this. Are they completely left out of this because the damage was already done by the person who originally bought the ticket through Ticketmaster?
So most of this, yes, is focused primarily on what we call the primary ticket market. So that's the very first sale of the ticket, because the venue itself generally picks the primary ticketer, i.e. who is the first person selling the tickets. But they don't have a lot of control over what we call the secondary ticketing market, i.e. when you're reselling, where you decide to do that, the venue doesn't itself usually get involved. So there are a bunch of concerns about the secondary market. There's some legislation pending in Congress that's focused on that. But this case is primarily about the primary ticket.
How difficult will it be for the prosecution to prove its case?
So, the standard is a preponderance of the evidence because this is a civil case.
Right.
But it's interesting, antitrust cases, by the time they get to this point, with the Justice Department bringing it to trial, very often the Justice Department wins. There's a pretty high bar for the Justice Department to file a monopolization case in the first place. And then, it has to get past the motion to dismiss. It has to get past summary judgment. This one is pretty interesting because it's pretty rare, actually, for antitrust cases to go before a jury. The only reason it's actually before a jury is because of the damages portion. But, the Justice Department was very interested in getting this before a jury because these are the people allegedly who have been harmed by this conduct.
Right, the peers.
They are like the people who might have actually gone to a concert. Live Nation a little bit earlier last week actually tried to insist that if you had ever bought a ticket through Ticketmaster, you were ineligible to be on the jury. And the judge actually threw out that request because he felt that it would have been impossible to actually seat a jury if one of the requirements was that you had never bought a concert ticket online.
Yeah.
So it's entirely possible that these people have used Ticketmaster's product before. But, in order to be seated on the jury, they had to insist that they could be impartial and fair. And so, we'll see what they say. Juries much more frequently find for antitrust plaintiffs. So it's interesting that Live Nation wanted to take this gamble.
It really is. And at some point, there is going to be, let's say if they find in favor of the Department of Justice, there is a chance that Live Nation might have to be broken up. What would that even look like?
So the Justice Department and the state AGs say that in this case, they don't think it would be that hard because these used to be separate companies. And in their view, this is now a vertically integrated company. Live Nation does the concert promotions. That is the all of the logistics behind having a live music event. Whereas Ticketmaster is a ticketing service. It is, primarily a website that integrates with websites of venues. So these two things don't have to go together. And therefore, it would not, in their view, be necessarily that difficult to separate them.
So it would then just go back to what it was before 2010, Live Nation and Ticketmaster. Here's your tickets and here's your venue.
Yes, that's the idea of the Justice Department. It would separate these two things into two companies, and they would just go back to the way that they had done business before.
Okay, we're going to watch and see how this develops right along with you, Leah. Thank you so much for talking to us.
Thank you for having me.
Bloomberg News antitrust reporter Leah Nyland. And just ahead, we're going to take a look at one major business. They haven't had to worry about antitrust issues at all. That's the great American pastime of baseball. But how did they get past that? I'm Amy Morris, in for June Grasso, and this is Bloomberg.
You're listening to Bloomberg Law with June Grasso from Bloomberg Radio.
You're listening to the weekend edition of Bloomberg Law. I'm Amy Morris, filling in for June Grasso. June is off this week. Major League Baseball is a massive organization and is exempt from federal antitrust law. Now, this week, the Supreme Court refused to hear an appeal to challenge this longstanding exemption. Why the MLB Players Association is fighting to change it. We get more on the history of this and why the MLB Players Association is fighting to change it with Martin Edel, co-chair of Golston and Storr's sports law practice and adjunct professor at Columbia Law School. Okay, Martin, thank you so much for joining us today.
Amy, thank you so much for having me.
The High Court called this exemption an aberration. It's clearly unusual. Why is baseball so special?
Well, but baseball is magical in many ways because it stirs everyone's imagination. People from the farmlands joined baseball when it first started. It became a path for immigrants to become part of American society, and it's easy to understand the basics, not the real strategy, but the basics. So it tends to appeal to everyone. And in that way, it is different than many sports, but the same as many other sports, at least economically and perhaps legally, except as we're about to get into.
Okay, let's talk about that. Why was this exemption created for baseball in the first place?
You have to go back to 1922 when the Supreme Court, U.S. Supreme Court, first looked at baseball and whether it was subject to the antitrust laws. Now, put yourself in the time frame. In 1922, the GIs had just come back from World War I and had lots of cash to spend, particularly on leisure topics. You had a Supreme Court which had a very cramped view of the Commerce Clause, tending to restrict its availability. And you had the Black Sox scandal by 1922. So you put these three things together, and the Supreme Court looks at baseball in 1922, and it dealt with an ownership dispute at the time. And an opinion written by none other than Oliver Wendell Holmes, one of the great jurists on the Supreme Court, he decided that baseball was an exhibition that was not involved in interstate commerce and therefore was exempt from the antitrust laws because, as we know, Congress gets its power to regulate from Article 1, Section 8, the Commerce Clause. If you're not in commerce, Congress can't regulate that type of activity. So that was the start of the baseball exemption. I must say it made little sense in 1922, and as I'm sure we'll get into, it makes even less sense 104 years later.
Well, I was going to say maybe in 1922 it wasn't interstate commerce, but today it's worldwide. It's America's pastime. So how has it managed to survive any challenges for these changes?
So what we've had is the Supreme Court has looked at the baseball exemption two more times after 1922. Once in 1953 in a case called Toulson against the New York Yankees, where Mr. Toulson was claiming that something called the Baseball Reserve Clause was an antitrust violation. It restricted players to particular teams and didn't give them any mobility to move to another team, such as we now see in free agency. And the Supreme Court looked at this case, 6-sentence decision. It was called per curiam because it was by the court, no individual author. And in 6 sentences, the Supreme Court said, stare decisis. We had decided this 31 years ago, and therefore there's no reason to change. Congress could have acted to eliminate the baseball exemption and did not do so. So that's the end of it. Then in 1972, we have the Supreme Court looking at it again in a case called Flood against Kuhn. This is sometimes referred to as the Kurt Flood case. And what happened there, you now had a 5-3 decision by the Supreme Court. The major decision was written by Justice Blackmun. For those who like elegance of language, the first third of his decision is this great elegy to the game of baseball. The second third of his decision is based on Kurt Flood's outstanding statistics as the premier center fielder of his time. And the third of his decision was, hey, this is an aberration, but it's our aberration. And while there's something to be said for consistency, even when it's layered in inconsistencies, we're going to uphold the baseball exemption. Congress hasn't stepped in. There's been what the court called positive inaction, and therefore baseball exemption stands. Sounds quite Ralph Waldo Emersonian in its scope.
So it sounds like also because the Supreme Court opted not to take up this case, that, what did you call it? The inaction?
Positive inaction.
Positive inaction remains.
Correct. And since 1972, we've seen a whole bunch of developments. We've had on the congressional front, Congress in 1997 or 1998, passed something called the Kurt Flood Act. Unfortunately, Kurt Flood had passed away before Congress enacted this, and President Clinton signed it into law. That said that baseball players for Major League Baseball had the right to sue under the antitrust laws. Of course, by that time, it didn't matter much because baseball had developed a union, the Major League Baseball Players Union, and the Major League Baseball owners had negotiated a collective bargaining agreement. Where you have a collective bargaining agreement, the labor law takes precedence over the antitrust laws, and so there is no such thing as an antitrust violation for player disputes as long as there is a collective bargaining relationship. So it was a sop to, unfortunately, at that time, the deceased Mr. Flood, but it didn't matter much. You had a whole bunch of lower court cases coming up challenging the scope of the baseball exemption. Why? Because this exemption did not apply to any other sport. The Supreme Court and all lower courts had held professional football, professional hockey, professional basketball, theatrical exhibitions, you name the type of entertainment form, the Supreme Court and the lower courts have held they're subject to the antitrust laws. Not so for the great game of baseball. So lower courts tried to limit the scope, and ultimately they found that the circuit courts of appeals did not agree and held that baseball is not subject to the antitrust laws because of the exemption.
So in this case, if this appeal had been successful, how would that change Major League Baseball, how we experience it as fans, how it actually is run as an organization?
I think the answer is not much. So what we're talking about is the Congrejeros decision that where the Supreme Court earlier this week, denied a petition for a writ of certiorari. What that affects is not Major League Baseball, but the minor leagues. This involved Puerto Rican baseball leagues. And were they subject to the same baseball exemption? Were the players there subject to the same baseball exemption? The First Circuit Court of Appeals held the baseball exemption applied, and therefore it seemed to expand it beyond the scope of what the Supreme Court had held 3 times applied to Major League Baseball. So the effects would be to minor leagues, non-sanctioned leagues, and, as I'm sure you're going to ask me, the NCAA.
Right, exactly. I was stopping other organizations like the NCAA because I keep thinking about things like name and image and likeness and the portal and how students are now able to lobby for more money, which was unheard of back in my day. So what's stopping other organizations like the NCAA from lobbying for this type of an exemption?
So great question. And the answer is they are lobbying for an exemption. I can't tell you every day, but the NCAA has lobbyists who are going to Congress on a regular basis and claiming that the NCAA should be exempt, at least in some of its activities, from the scope of the antitrust laws. The principal reasons given by the NCAA are 1, money, and 2, money. And the reason for this is antitrust lawsuits are so expensive and take so much time and divert energy that they, in fact, divert attention from the scope of the activities that the parties want to engage in and take on a life of their own.
How does that not apply to baseball, though?
It would, but for these 3 Supreme Court cases.
Okay. So what happens now? There have been challenges. They get shot down or they're not heard at all. Is this just the way it is? Baseball has this antitrust exemption?
So the answer is yes and no. Okay. That's my legal and lawyerly type answer. Yes, because we have 3 Supreme Court cases which uphold the baseball exemption. Lower courts can't change that. What can change that is Congress. If Congress wanted to jump into the fray, and that's in effect why the NCAA is lobbying Congress now, it can create exemptions to the antitrust laws. The antitrust laws are congressional laws. They're not constitutional laws, and they can be changed by Congress or modified by Congress. So that's one avenue. Another avenue would be if the Supreme Court waded in again, which doesn't look likely. It's had ample opportunity over the last 54 years since the Flood case was decided, and it's chosen not to do so. So those are the 2 areas. A third area may be private parties. If, for instance, Congrejeros decided to develop a collective bargaining relationship with its players, and the players would unionize and then perhaps be subject to the scope of the National Labor Relations Act, they could then bargain without the sort of Damocles of an antitrust suit hanging over their heads, because the antitrust laws would be superseded by the collective bargaining relationship.
Marty, we're going to leave it there. Thank you so much for taking the time with us. This was fascinating.
Amy, thank you so much for having me. I've really enjoyed myself.
Marty Edel is co-chair of Goulston and Storr's sports law practice. And that does it for this edition of Bloomberg Law. Subscribe to the Bloomberg Law podcast on Apple, Spotify, or wherever you get your podcasts so you never miss an episode. I'm Amy Morris, in for June Grasso. This is Bloomberg. Stay with us. Today's top stories and global business headlines are coming up right now.